Good morning, franchisees. We're quickly going to start with the NCR Compliance Report Workshop. This is just the guidelines for the compliance report that needs to be filled in. We are taking you through the steps, question for question. If you have any additional questions, please feel free to send the correspondence through at the bottom of the screen. Or what you else can do is maybe just send me the questions and answers or the questions via email. Then I can respond to you. Okay, so we're going to start with the compliance guidelines. This is just to give you the feedback or to make sure that everything is 100% with the packages that needs to be submitted. Okay, so the compliance report completion is what we're going to do today. And then afterwards, for those guys who going to need our assistance, or for anybody else, True Accounting don't need to worry. We're doing the submissions in any case for you guys. But anybody else, if you need our assistance, feel free to contact me. You can either send me an email or you can give me a call. Okay. The rest is just to make sure that all documentation that needs to be submitted, and we're going to send you the packs that needs to be filed in your white files, the NCR files that's in your stores. Okay. Okay, so the NCR compliance and reporting, the forms that needs to be filled in every year is as follows. The statistical return, this was filed in February, the form 39. If you are more than 15 million, please make sure that you do this form 39 every quarter. If not, this is only a yearly submission. The information that we get for the Form 39 is from your City Trader and your PDA website, and we usually combine these two and then we submit it as one form to the NCR. Then we need to comply with the conditions of registrations. The other documents that we need to submit is the annual financial statements. These are now about to be done, and those guys not with True Accounting, please ensure that you send me your financial statements when you need us to submit anything. Okay. Then the Form 40. This report is also, you'll get this from your accountant. They need to fill this in. And this also needs to be submitted with the compliance report. Then we have the compliance report that we're going to do today. And then the assurance report afterwards, that it's also coming from your accountants. Okay. So we've already done the statistical returns. The conditions of registrations is met, and then the annual financial statements, that all needs to be finalized by end of August. The annual financial and operational return that's going to be received from your accountants. Then the compliance report is what we do today, and then the assurance report is afterwards. Okay. Okay, so just the guidelines on the compliance report. The purpose of the report: for management of credit provider to confirm whether the credit provider conducts its operation in accordance with the Act, the regulations, conditions of registrations. This is effective date from the 1st of January 2011. So everybody with the year ends of February needs to be submitted by end of August. If you have any other financial year end, this needs to be submitted 6 months afterwards. So for those guys with the February financial year end, here's just a timeline. The submissions need to be done by the 31st of August. Now, I would like to ask everybody to ensure, if you need True Accounting to assist you with these submissions, please have this with us by the 15th of August. It gives us enough time to ensure that everything is there, and also enough time for us to compile the packs and submit. Okay, so we're going to start with your first page of the compliance report. I'm just giving everybody time to make sure that they have all the reports that's necessary. This is the pack that was sent through to you from your RON. This document was supposed to be sent to you on the 20th of July. Okay. So when you go to your second page, your page number 4, you'll get these documents. Okay. So the first information that you need to fill in for us is your registered name. That's your PTY or your CC's name. Afterwards, your registration number. This is your NCR CP number. So this is the number that is showing on your certificate. Your reporting period is from the 1st of March 2014 till the 28th of February 2015. Please make sure that you have these dates as correct. The two ticks that you need to make on the type of credit provider, we are a pawnbroker and microlender. Okay, so we're just going to start with the questions. I'm going to read out the questions and then just please tick yes, no, not applicable, and the annexion numbers. I'm going to show it all on here. Please feel free, if you get stuck, rather do not answer one, but make sure that you answer them according to what we state on the slideshow. Okay. So the first question is the credit provider a bank, mutual bank, or other institution licensed to take deposits? If the answer is no, please answer question 1.2 to 1.5 below. The answer is no. Question 1.2. Has any natural person who exercises general management or control of the credit provider, whether alone or with others, become disqualified from individual registration as contemplated in section 46(3)? The answer is no. Question 1.3. If the answer to question 1.2 is yes, has the natural person advised the national credit regulator thereof in terms of section 47.3? This answer is not applicable. Question 1.4. Has any natural person who acquired a financial interest in the credit provider, whether alone or with others, became disqualified from the individual registration as contemplated in section 46.3? The answer is no. You'll note at question 1.3 there's now annexion number 1.1. Please put that in as well. Everywhere where we're going to have a not applicable, we'll have an annexion number as well. Okay, so question 1.4 is no. Question 1.5. If the answer to question 1.4 is yes, has the natural person advised the national credit regulator thereof in terms of section 47.3? The answer is not applicable, and our annexure is 1.2. We'll get to these annexures now. This is part of the pack that we're going to send through to every store that they need to fill into the NCR files. This will be sent out within the week, so you can just have everything ready. These annexures is not necessary to be sent through to True Accounting. We already have all the annexures. So the only document that we need is your compliance report that's filled in and signed. Okay, let's go to question number 1.6. Did the credit provider provide a report to the National Credit Regulator on the anniversary date of its registration, detailing its compliance with the relevant industry code or legislation in respect of broad-based Black economic empowerment? In regards of the BEE statuses of stores, we haven't started doing any scorecards with the stores. NCR has not yet asked us to have a BEE certificate, but they are starting to implement this. So we are looking at doing the BEE certificates by the year end, maybe November, December, but this will be communicated through to all the stores. This is a process to go through, so we are trying to extend the period as far as possible, seeing that NCR is not yet disqualifying us from being an NCR provider, a credit provider, due to that fact. But we'll have to look into that. So question 1.6, the answer is no. If you do have a broad-based Black Economic Empowerment Certificate, please answer yes. Then you'll have to send that through to me as well, so we can submit it with your compliance report. Question 1.7, did the credit provider on the anniversary date of its registration submit to the National Credit Regulator copies of scorecards completed or assessments issued by an accredited verification agency as contemplated in the relevant industry code or legislation in respect of BEE? The answer is no. All of these annexures that is marked on the right-hand side, or the descriptions on the right-hand side, please do not fill them on the form please do not fill this in on the form. The only thing that you need to fill in is those tick boxes that is actually part of the form. These are just additional notes for us when we look at the packs that we're going to have to see what was the actual answer that was sent through to NCR. Question 1.8. When applying for registration to the National Credit Regulator, did the credit provider make commitments in respect of combating over-indebtedness in accordance with Section 48(1)(b)? The answer is yes. I'm leaving this page up for a while, so you just make sure that all the ticks are done and the annexures are written in. Okay, let's go to the next page. Question 1.9. If the answer to question 1.8 is yes, provide a report detailing progress made by the credit provider in combating over-indebtedness and the intentions on the credit provider for the forthcoming reporting period. Attach the report as an annexure and indicate the annexure number. This is annexure 2. This is the affordability test that we are now doing on the PDA side, that is now been implemented on payday advance. So all the processes and steps to follow is on annexure 2. Question 1.10. Does the credit provider have procedures in place to comply with the conditions of registration imposed by the National Credit Regulator in terms of Section 48? The answer is yes. Question 1.11. Is the credit provider an accountable institution or reporting institution in terms of the Financial Intelligence Center Act number 38 of 2001? If the answer is yes, please answer question 1.12 below. The answer is no. Question 1.12. Credit providers that are accountable institutions in terms of FICA are required to establish and verify the identity of their clients, report suspicious transactions, keep records, report cash transactions in excess of a prescribed limit, and train staff on their obligations in terms of FICA. Reporting institutions as required to report suspicious transactions and cash transactions in excess of a prescribed limit. Does the credit provider have procedures in place to comply with the provisions of FICA that are applicable to the credit provider as required in terms of Section 52(b)? The answer is not applicable. Question 1.13. Has the credit provider paid its annual registration renewal fee as prescribed in accordance with Section 51(1)? The answer is yes. If you do have this proof of payment, please send it to us as well. This is very important. This is very important to give us your proof of payment. Question 1.14. Does the credit provider post its registration certificate or duplicate registration certificate in every premises from which it conducts the activities for which it is registered? The answer is yes. If you have 2 branches, make sure that you have 2 certificates. This is very important. Question 1.15. Does the credit provider reflect its registered status and registration number in a legible typeface on all its credit agreements and communications with the consumer? The answer is yes. We are now at section B, consumer credit policy. Question 2.1. Does the credit provider have procedures in place to protect a person's right to apply for credit to the credit provider? The answer is yes. Question 2.2. Does the credit provider have procedures in place to ensure that it does not unfairly discriminate against any person as required in terms of section 61(1)? The answer is yes. I'm going to go through these questions fairly fast so we can get it done. Okay, question 2.3. Does the credit provider have procedures in place to respond to any request by a consumer in terms of section 62(1), including providing the dominant reason of refusing to enter into a credit agreement with a consumer? The answer is yes. Question 2.4. Does the credit provider have procedures in place to advise a consumer of the name and contact details of a credit bureau from whom an adverse credit report has been received in terms of section 62(2)? The answer is yes. Has the credit provider submitted a proposal to the National Credit Regulator in respect of the languages in which the credit provider proposes to make documents available to the consumer? Answer is yes. Question 2.6. If the answer to question 2.5 is yes, has the proposal been approved by the National Credit Regulator? Yes, it has been. On the right-hand side, you'll see there's CCNCA 10 and CCNCA 11. These are part of the packs, and you will see the letters that were submitted as well as the letters that we received back from NCR. Question 2.7. Does the credit provider make documents available in plain and understandable language in terms of section 64(1)? The answer is yes. Does the credit provider charge a fee for the delivery of an original document or original copy of any document required to be delivered in terms of the Act? The answer is no. Question 2.9. Does the credit provider have procedures in place to ensure that it does not discriminate against or penalize a consumer when a consumer exercises, asserts, or seeks to uphold any rights set out in the Act or in a credit agreement? The answer is yes. Just going to leave it open for a while so you can just make sure that you have all the ticks. Question 3.1. Does the credit provider have procedures in place to protect the confidentiality of a consumer's confidential information? Yes, we do. Question 3.2. Does the credit provider have procedures in place to ensure that confidential information is only used for the purposes provided for in the Act? Answer is yes. Question 3.3. Does the credit provider have procedures in place to ensure that confidential information is only released or reported to the extent permitted or required in the Act or other legislation? Answer is yes. Question 3.4. Does the credit provider have procedures in place to ensure that all the information prescribed in section 69(2), 3 and 4 is reported to the National Register or Credit Bureau with the prescribed time and in the prescribed manner and form? Our answer is area for improvement. Question 3.5. Does the credit provider have procedures in place to advise a person of any prescribed adverse information concerning the person which the credit provider intends to report to a credit bureau within the prescribed time before such information is reported? The answer is yes. Question 3.6. With reference to question 3.5, does the credit provider have procedures in place to provide the consumer with a copy of the prescribed adverse information to be reported to the credit bureau? Our answer is yes. Question 4.1. Does the credit provider offer any credit agreement on the basis that the agreement will automatically come into existence unless the consumer declines the offer? Note that this is prohibited in terms of section 74(1). Answer is no. Question 4.2. Does the credit provider have procedures in place to ensure that an offer to increase a credit limit under the credit facility on the basis that the limit will automatically be increased unless the consumer declines the offer will only be made as provided for in terms of section 119(4)? The answer is not applicable. Annexure 1.4. Question 4.3. Does the credit provider have procedures in place to ensure that any amendments or alterations to a credit agreement made on the basis that the alteration or amendment will automatically take effect unless rejected by the consumer is only made in accordance with the provisions of section 104, 116A, 118.3, or 119.4? The answer is not applicable. Annexure 1.5. Question 4.4. Does the credit provider have procedures in place to ensure that the credit provider, when entering into a credit facility, provides the consumer with the option to decline a pre-approved annual credit limit increase as contemplated in section 74(6)(a)? The answer is not applicable. Annexure 1.6. Please make sure that you put in the annexure numbers and not the page numbers next to it, only annexure numbers. Question 4.5. Does the credit provider have procedures in place to ensure that the credit provider, when entering into a credit agreement, provides the consumer with the option to be excluded from telemarketing campaigns, from any marketing or customer list, or any mass distribution of email or SMS messages as contemplated in section 74(6)(b)? The answer is yes. Question 4.6. Does the credit provider maintain a register of all options selected by the consumer in terms of section 74(6) and in accordance with the requirements set out in regulation 58? The answer is yes. Question 4.7. Does the credit provider have procedures in place to ensure that it does not act in any manner contrary to the options selected by the consumer in terms of section 74(6)? Answer is yes. Question 4.8. Does the credit provider conduct monitoring of compliance with the procedures referred to in question 4.7? Answer is not applicable. Annexure number 1.7. Question 4.9. If the answer to question 4.8 is yes, has the monitoring referred to in question 4.8 above revealed any instances of non-compliance? If yes, please provide details thereof in an annexure hereto and indicate the annexure number. This is not applicable and is annexure 1.8. Question 4.10. Does the credit provider have procedures in place to ensure that an advertisement contemplated in section 76(4) does not advertise a form of credit that is unlawful and is not misleading, fraudulent, or deceptive? The answer is yes. Question 4.11. Does the credit provider have procedures in place to ensure that an advertisement contemplated in section 76(4) that contains a statement of comparative credit cost, shows cost for each alternative being compared, shows rates of interest, shows all other costs of credit for each alternative, is set out in accordance with regulation 21(4) and is contemplated by the prescribed warnings? Yes. Question 4.12. Does the credit provider have procedures in place to ensure that any advertisement that discloses only the interest rate or the maximum and minimum interest rate indicates that an initiation fee and a service fee will be charged if such fees are applicable? Answer is yes. Question 4.13. Does the credit provider have procedures in place to ensure that an advertisement that discloses a monthly installment or any other cost of credit also discloses the installment amount, the number of installments, the total amount of all installments, including interest, fees, and compulsory insurance, the interest rate, and the residual or final amount payable, if any? The answer is yes. Question 4.11. Does the credit provider have procedures in place to ensure that an advertisement or a direct solicitation for credit does not contain the following statements or phrases, or similar phrases: no credit checks required, blacklisted consumers welcome, or free credit? The answer is yes. Question 4.15. Does the credit provider have procedures in place to ensure that the information disclosed in terms of regulation 21(2) and 3 is of no smaller size than the average font size used in the advertisement and is displayed together? The answer is yes. Question 4.16. Does the credit provider have procedures in place to ensure that equal prominence is given to the information disclosed in terms of Regulation 21(2) and 3, whether by audio or visual disclosure? The answer is yes. Question 5.1. Does the credit provider have a policy in place to combat over-indebtedness and prevent reckless credit? If yes, please attach a copy of this policy and indicate the annexure number. This is yes, and it's annexure 3. Question 5.2. Does the credit provider have procedures in place to conduct the assessment required in terms of Section 81(2) prior to entering into a credit agreement? Answer is yes. Question 5.3. Does the credit provider have procedures in place to ensure that the credit provider does not enter into a reckless credit agreement with a consumer? The answer is yes. Question 5.4. Does the credit provider provide staff training on the procedures in place to combat over-indebtedness and reckless credit as referred to in Section 5.1 to 5.3? The answer is yes. Question 5.5. Does the credit provider conduct monitoring of staff members' compliance with the policies and procedures referred to in question 5.1 to 5.3 above? The answer is yes. Question 5.6. If the answer to question 5.5 is yes, has the monitoring referred to in question 5.5 above revealed any instances of non-compliance? If yes, please provide details thereof in an annexure hereto and indicate the annexure number. The answer is no. Annexure 4 for reference purpose only. This is part of the packs that we're going to send out soon. Question 5.7. Does the credit provider have procedures in place to complete and submit Form 15 to the National Credit Regulator in respect of any credit extended in terms of a school or student loan, an emergency loan, or a public interest credit agreement within 30 business days of signature thereof, or at the end of the month in which an agreement was conducted? This is not applicable. Annexure 1.9. Question 6.1. Section 89(2) sets out circumstances in which a credit agreement would be regarded unlawful. Does the credit provider have procedures in place to ensure it does not enter into such unlawful credit agreements? The answer is yes. Section 92 declares certain provisions in a credit agreement unlawful. Does the credit provider have procedures in place to ensure that its credit agreements do not contain any of these unlawful provisions? The answer is yes. In terms of Section 92L, the following provisions in a credit agreement have been declared unlawful: where a consumer agrees to deposit his identity document, credit or debit card, bank account or ATM card, or other similar documents with a credit provider, where a consumer provides his personal identification code or number to access an account to the credit provider. Does any credit agreement or supplementary agreement of the purchaser contain such a provision? Answer is no. Question 6.4. In terms of Section 91A, a credit provider must not enter into a supplementary agreement or sign any document that contains a provision that would be unlawful if it were included in a credit agreement. Does the credit provider have procedures in place to ensure that the provisions declared unlawful in terms of Section 92 are not included in any supplementary agreement? The answer is yes. Question 7.1. Question 7.1. In terms of Section 92L, a credit provider must provide a consumer with a pre-agreement statement and quotation in Form 20 when entering into a small credit agreement. Does the credit provider have procedures in place to comply with this requirement? The answer is yes. Question 7.2. When entering into an intermediate or large credit agreement with a consumer, the credit provider must provide the consumer with a pre-agreement statement and a quotation in accordance with Section 92.2 and Regulation 29. Does the credit provider have procedures in place to comply with this requirement? This is not applicable. Annexure 1.10. Question 7.4. For a period of 5 business days after providing the consumer with a quote in respect of a small agreement, a credit provider must enter into that agreement at the request of a consumer in accordance with Section 92.3a. Does the credit provider have procedures in place to give effect to this? The answer is yes. Question 7.5. For a period of 5 business days after providing a consumer with a quote in respect of an intermediate or large agreement, a credit provider must enter into the agreement at the request of a consumer in accordance with Section 92.3b. Does the credit provider have procedures in place to give effect to this? This is not applicable, and this is Annexure 1.11. Question 7.6. Section 93L provides that the credit provider must deliver to the consumer without charge a copy of the document that records their credit agreement. Does the credit provider have procedures in place to give effect to this? The answer is yes. Question 7.7. Section 93.2 and Regulation 30 provide that a document that records a small agreement must contain all the information set out in Form 20.2. Does the document that records the small agreement of the credit provider comply with this requirement? The answer is yes. Question 7.8. The requirements for intermediate and large agreements are set out in Regulation 31. Does the document that records the credit provider's intermediate or large agreement comply with these requirements? This is not applicable. Annexure 1.12. Question 8.1. A credit provider may not require a consumer to pay any cost other than that allowed in terms of the Section 101(1). Does the credit provider have procedures in place to comply with this requirement? The answer is yes. Question 8.2. Does the credit provider monitor whether the maximum rates or charges prescribed in terms of Section 101(1) are exceeded? The answer is yes. Question 8.3. If the answer to question 8.2 is yes, has this monitoring revealed any instances of non-compliance? If yes, please provide details thereof in a separate annexure and indicate the annexure number. The answer is no. Question 8.4. Section 102(1) allows certain fees and costs to be included in the principal debt in respect of installment agreements, mortgage agreements, secured loans, or leases in terms of Section 102(2). The credit provider may not charge the consumer more than the actual amount paid or the fair market value of the service. Does the credit provider have procedures in place to comply with these requirements? The answer is not applicable, and the annexure is 1.13. Question 8.5. In terms of section 103.3, the credit provider may not debit any interest charge before the end of the day to which the interest applies. Does the credit provider have procedures in place to comply with this requirement? The answer is yes. Question 8.6. In terms of section 103.4, a credit agreement may provide for an interest rate to vary during the term of the agreement if the variation is fixed in accordance with the reference rate stipulated in the agreement. Does the credit provider have procedures in place to comply with this requirement? The answer is not applicable and is annexure 1.14. Question 8.7. Regulation 40 prescribes the manner in which interest must be calculated. Does the credit provider have procedures in place to ensure that interest is calculated in accordance with this requirement? The answer is yes. Question 8.8. Regulation 42, 43, and 44 prescribe the maximum interest rate, initiation fee, and service fee that may be levied. Does the credit provider have procedures in place to ensure that these are not exceeded in respect of a credit agreement? The answer is yes. Question 8.9. In terms of section 103.5, once a consumer is in default, the cost of credit amounts that accrue in terms of section 101 A to G may not exceed the unpaid balance of the principal debt at the time of default. Does the credit provider have procedures in place to comply with these requirements? The answer is yes. Question 8.10. In terms of section 106, 1 and or 3, a credit provider may require a consumer to maintain credit insurance. In terms of section 106.4, the credit provider must give and inform the consumer of the right to waive that proposed policy and substitute a policy of the consumer's own choice. Does the credit provider have procedures in place to comply with this? This is not applicable and is annexure 1.15. Question 8.11. In terms of section 106.5b, where a credit provider arranges an insurance policy on behalf of a consumer, the credit provider must disclose the cost to the consumer of the insurance applied. The credit provider must also disclose the amount of any fee, commission, remuneration, or benefit receivable by the credit provider in respect thereof. Does the credit provider have procedures in place to disclose these amounts to the consumer in Form 21? This is not applicable and is annexure 1.16. Question 8.12. In terms of section 106.6a, where a consumer elects to substitute an insurance policy of the consumer's own choice, the credit provider may require that the consumer allow the credit provider to pay the premiums due under the policy and then bill the consumer for those premiums. Does the credit provider have procedures in place to obtain an instruction from the consumer to this effect in Form 22? The answer is not applicable and is annexure number 1.17. Question 8.13. In terms of section 106.6b, where the consumer elects to substitute an insurance policy of the consumer's own choice, a credit provider may require the consumer to name the credit provider as a loss payee under an insurance policy. Does the credit provider have procedures in place to obtain an instruction from the consumer to this effect in Form 23? The answer is not applicable, annexure 1.18. Question 9.1. In terms of Section 127.1, a consumer who has entered into an installment agreement, secured loan, or lease may give notice to a credit provider to terminate the agreement and return the goods to the credit provider. The consumer may also require these credit providers to sell the goods within 10 business days thereof, and in terms of the Section 127.2, the credit provider must give the consumer written notice setting out the estimated value of the goods. Does the credit provider have procedures in place to comply with these requirements? The answer is not applicable and is Annexure 1.19. Question 9.2. In terms of Section 127.3, a consumer may, within 10 days after receipt of a notice referred to in question 9.1, withdraw the notice to terminate the agreement and resume possession of any goods that are in the credit provider's possession, provided that the consumer may not act in terms of this section if the consumer is in default of the credit agreement. Does the credit provider have procedures in place to comply with these requirements? The answer is not applicable, Annexure 1.20. Question 9.3. In terms of Section 127.5, after selling the goods referred to in question 9.2, the credit provider must give the consumer written notice of the following: the settlement value of the agreement prior to the sale, the gross amount realized on the sale, and the net proceeds after deducting permitted default charges and any reasonable cost allowed. Does the credit provider have procedures in place to give the consumer written notice after selling goods in terms of Section 127, stating the required information? The answer is not applicable, Annexure 1.21. Question 9.4. In terms of Section 129.1, the credit provider must give the consumer notice before commencing legal proceedings to enforce a credit agreement. Does the credit provider have procedures in place to comply with these requirements? The answer is yes. Question 9.5. The notice referred to in question 9.4 above must comply with the requirements of Section 129.1a or Section 86.10, as the case may be. Does the credit provider have procedures in place to comply with these requirements? The answer is yes. Question 9.6. A credit provider may approach the court for an order to enforce a credit agreement only if the consumer has been in default under that credit agreement for at least 20 business days and the requirements of the Section 131 have been met. Does the credit provider have procedures in place to comply with these requirements? The answer is yes. Question 9.7. A credit provider may not approach the court for an order to enforce a credit agreement to which Sections 127, 129, and 131 apply, unless the procedures contained in those sections have been complied with. Does the credit provider have procedures in place to give effect to this? The answer is yes. Question 9.8. A credit provider may not approach the court for an order to enforce a credit agreement where a matter arising under that credit agreement is pending before the tribunal. Does the credit provider have procedures in place to give effect to this? The answer is yes. Question 9.9. A credit provider may not approach the court for an order to enforce a credit agreement where the matter is before a debt counselor, alternative dispute resolution agent, consumer court, or ombud with jurisdiction. Does the credit provider have procedures in place to give effect to this? Answer is yes. Question 9.10. A credit provider may not approach the court for an order to enforce a credit agreement where the consumer has surrendered the property to the credit provider and the property has not yet been sold. Does a credit provider have procedures in place to give effect to this? This is not applicable. It's Annexure 1.22. Question 9.11. A credit provider may not approach the court for an order to enforce a credit agreement where the consumer has agreed to a proposal made in terms of Section 129(1)(a) and acted in good faith in fulfillment of that agreement. Does the credit provider have procedures in place to give effect to this? The answer is yes. Question 9.12. A credit provider may not approach the court for an order to enforce a credit agreement where the consumer has complied with an agreed plan as contemplated in Section 129(1)(a). Does the credit provider have procedures in place to give effect to this? The answer is yes. Question 9.13. A credit provider may not approach the court for an order to enforce a credit agreement where the consumer has brought the payments due under the credit agreement up to date as contemplated under Section 129(1)(a). Does the credit provider have procedures in place to give effect to this? The answer is yes. Question 9.14. Prohibited collection and enforcement practices are specified in terms of Section 133. A credit provider or any agent of the credit provider must not, amongst other things, make use of the consumer's original identity document, credit or debit card, bank account or ATM card, or any similar device, and or the personal identification number used to access such card or device in any manner whatsoever when collecting or on or enforcing a credit agreement. Does the credit provider have procedures in place to comply with these requirements? The answer is yes. Question 10.1. Does the credit provider have procedures in place to retain the information required in terms of Regulation 55(1)(b) in respect of each consumer? The answer is yes. Question 10.2. Does the credit provider have procedures in place to retain the information required in terms of Regulation 55(1)(c) in respect of its operations? The answer is yes. Question 10.3. Does the credit provider maintain its records in electronic format? The answer is yes. Does the answer to question 10.3 is yes? Does the credit provider make use of the services of a third party to store such records? The answer is yes. Does the credit provider have procedures in place to retain the information required in terms of Regulation 55 for a period of 3 years from the date of termination of the credit agreement, or in the case of an application for credit that it is refused or not granted for any reason from date of receipt of the application? The answer is yes. Question 10.7. Does the credit provider maintain a register of its agents as required in terms of Section 163(2)(b) and in accordance with Regulation 59? The answer is not applicable and is Annexure 1.23. Question 10.8. Does the credit provider maintain a register of information in respect of each consumer as prescribed by Regulation 62? The answer is yes. Question 11.1. Did the annual disbursements of the credit provider exceed 15 million? This is a very important question, and I'm sure most of us is not yet there. There is a few stores that is above 15 million, but if you are unsure, rather do not answer this. This is the same figure that is showing on your form 39. So if you are unsure, rather do not answer this, and let's contact me later on and let's see in total what the answer is. But for most of us, the answer is no. If the answer to question 11.1 is yes, did the credit provider complete and submit the statistical return in form 39 to the National Credit Regulator in respect of the quarters and by the due dates referred to in Regulation 64? The answer is not applicable. It is Annexure 1.24. Question 11.3. If the answer to 11.1 is no, did the credit provider complete and submit the annual statistical return in Form 39 for the period 1st of January to 31st of December by the 15th of February for the reporting period? The answer is yes. Question 11.4. Did the credit provider submit its annual financial statements, including the auditor or accounting officer's report, to the National Credit Regulator within 6 months after the credit provider's financial year end for the reporting period? This will be submitted with this compliance report, so you can answer yes. Question 11.5. Did the credit provider submit an annual financial and operational return in Form 40 to the National Credit Regulator within 6 months after the credit provider's financial year end for the reporting period? The answer is yes. This will also be submitted with the compliance report. Question 11.6. Did the credit provider submit an insurance engagement report as contemplated in Regulation 68.2 to the National Credit Regulator within 6 months after the credit provider's financial year end for the reporting period? This is also yes. Question 12.1. Describe how the credit provider monitors compliance with the applicable provisions of the Act and/or regulations with specific reference to the following: procedures and controls in place to ensure compliance, roles and responsibilities of key stakeholders, and internal reporting undertaken. Attach your answer as a separate annexure and indicate the annexure number. This will be Annexure 5. On Section G, the annexures, this is just to note which annexures will be submitted with this pack. So we'll have Annexure 1, and then we will have Annexure 3, Annexure 5, and Annexure 2. Sorry about this mess. So the annexures that needs to be submitted is Annexure 1, 2, 3, and 5. Underneath this Section G is your compliance report sign-off. Please insert your company name on the first line. I, the undersigned, do hereby report on behalf of your company name with registration number. This is your NCR number. for the reporting period of 1st of March 2014 to 28 February 2015. Name of the person signing this report. Please put in your name. Designation of person signing this report. Put in your title. And the date, which is the 22nd of July 2015. And then please sign it. The documents that needs to be submitted. This is the guideline 2, which is the compliance report. Annexure 1, which is the schedule of not applicable answers. Annexure 2, combating of over-indebtedness progress report. Annexure 3, combating of over-indebtedness and reckless lending credit policy. Annexure 4, do not submit. This is not necessary to submit Annexure 4. Annexure 5 is the compliance assurance monitoring. The only 4 documents that needs to be submitted is Annexure 1, 2, 3, and 5. The rest of these documents mentioned is only is being sent to you, and this needs to be in your NCR file. I'm just going to mention them all. Your CCNCA 001 is your compliance management plan. CCNCA 002 is conditions of registration. CCNCA 003, compliance to industry codes for BEE. CCNCA 004, report on measures aimed at debt counseling and prevention of over-indebtedness. CCNCA 005 is your BEE certificate, if you do have one. CCNCA 006 is your cash converters lending procedures. CCNCA number 10 is your language proposal. CCNCA 11 is the language proposal acceptance. CCNCA 12 is the lending policy. And CCNCA 13 is your qualification policy. This is the final slideshow for this NCR workshop. Please feel free to ask any questions. You can either send it through to me on the page just below, or you can send me an email if you have any questions. Thank you so much and enjoy your day.